In this lesson, we're continuing our discussion of subject matter jurisdiction. Specifically, we're going to focus on federal question jurisdiction. So if we think back to our last lesson, again, over the basic requirements, we say to hear and decide a case before it, a court generally must have three things. Number one, court needs subject matter jurisdiction over the particular type of case before it. Number two, court needs personal jurisdiction over the defendant. And number three, we know the court needs proper venue based on locality. Of course, in this lesson, we're continuing our discussion of subject matter jurisdiction. If we think back to our last lesson, we kind of talked about the differences between state subject matter jurisdiction and federal subject matter jurisdiction. In this lesson, we're going to be focused on federal subject matter jurisdiction, which is basically exploring the ways that a federal court obtains subject matter jurisdiction over a case. Here we say other than subject matters exclusively allocated to federal courts by law. Remember, we talked about this in our last lesson. This is cases like admiralty, maritime, patent, copyright, bankruptcy cases. We know these types of cases are exclusively allocated to the federal courts by federal law. So outside of these cases, there are generally four main ways for a federal court to obtain subject matter jurisdiction over a case. We have federal question jurisdiction, diversity jurisdiction, supplemental jurisdiction, and removal. Of course, in this lesson, we're going to focus in on federal question jurisdiction. Okay, for a federal court to have federal question jurisdiction over a case, the cause of action must arise under federal law. So really, in this lesson, we're going to explore entirely what this concept of arise under federal law means, because that's what federal question jurisdiction comes down to. We're going to see for a federal court to have federal question jurisdiction, the rule statement is simply that the cause of action must arise under federal law. This is the language you're going to see courts use when we're talking about federal question jurisdiction. Okay, so before we get into really diving into this meaning, though, it's important to understand some of the basics, right? For federal question jurisdiction, we have essentially two components. We have a constitutional component that comes from Article 3, Section 2 of the U.S. Constitution, and we have a statutory component that comes from 28 U.S. Code Section 1331. So if we think to the U.S. Constitution, right, we know there's Article 1, Article 2, and Article 3. Article 1 essentially vests the power of the legislative branch to Congress. Article 2 vests the executive power to the President of the United States. And Article 3 vests the judiciary power to the United States Supreme Court and the entire federal court system. So Article 3 of the U.S. Constitution kind of sets up our federal court system. And if we look at Article 3, Section 2, we see this really establishes the scope and foundation of federal question jurisdiction. If you're thinking back to the Constitution, well, if you're going to vest the power of the judiciary to the federal courts, what types of cases can those federal courts hear? Well, Article 3, Section 2 kind of lays out some examples. It says these are the types of cases that these Article 3 federal courts are going to be able to hear. So this is where federal question jurisdiction, this concept comes from. It's derived from Article 3, Section 2 of the U.S. Constitution. In 1824, we get this really landmark Supreme Court decision in Osborn v. Bank of the United States. Without going into too much detail here, to give a simplified version, essentially what happens is we have a claim that's brought into federal court, and that claim has ingredients, what the Supreme Court of the United States refers to as ingredients, has ingredients of both state law and federal law in it. So we have this claim that gets to federal court, but it's kind of a mix-up. It's got ingredients of state law and ingredients of federal law. And at this time in 1824, obviously we don't have 28 U.S. Code Section 1331 that really defines more narrowly what the requirements of federal question jurisdiction are. Remember, here in 1824, the Supreme Court's kind of just looking at Article 3, Section 2. And they're trying to determine, well, what do we do here? We have this claim that's come before us. It's in federal court, but it has ingredients of state law in it. Can the federal court exercise jurisdiction over a case that has ingredients of state law in it? And essentially, in Osborn v. Bank of the United States, the Supreme Court says, look, even if there are some ingredients of state law, if there's a federal law ingredient, then the federal court is going to have jurisdiction over the case. Okay, so this is a really seminal landmark decision. It grants broad authority to the federal courts to exercise jurisdiction over cases. If there's a federal ingredient, basically Osborn v. Bank of the United States saying if there's a federal ingredient, then the federal court can exercise subject matter jurisdiction over the case. Of course, over, the next 100, now 200 years, this has been refined in, but this establishes the concept of federal question jurisdiction. It comes from Article 3, Section 2, and Osborn v. Bank of the United States that comes along and says, well, even if there is some state law kind of ingredients mixed in, as long as we have that federal law ingredient in there, the federal court has jurisdiction. Okay, then we fast forward 100, 200 years later, this gets refined, right? We get 28 U.S. Code Section 1331, which establishes the modern requirements of federal question jurisdiction. So we understand that Article 3, Section 2 lays kind of the foundation and the scope. Osborn v. Bank of the United States comes along and says, well, if there's state law and federal law, as long as there's a federal law ingredient, court can exercise jurisdiction, federal court can exercise jurisdiction. Then over time, this broad grant of authority kind of gets narrowed and honed in. Eventually, we get 28 U.S. Code Section 1331 that establishes the modern requirements of federal question jurisdiction. This is what we would apply on a law school or bar exam fact pattern. We'd look at 28 U.S. Code Section 1331. This is what courts today are going to apply to determine whether federal question jurisdiction exists. Here, we say, for a federal court to have federal question jurisdiction over a case, the requirements of 28 U.S. Code Section 1331 must be met. 28 U.S. Code Section 1331 states, federal courts shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. Put simply, what you'll hear courts say when they're stating this rule, the cause of action must arise under federal law. Okay, for Section 1331 to be satisfied, the cause of action must arise under federal law. So, of course, this begs the question, well, how does a cause of action arise under federal law? Well, see, we have two rules that we have to think about here. To arise under federal law, pursuant to 28 U.S. Code Section 1331, the significance rule and the well-pleaded complaint rule both must be satisfied. So if we state these rules together, it'll sound like this. A cause of action arises under federal law if a sufficiently significant federal question is presented on the face of the plaintiff's complaint. So this first element is the significance rule, and this second element is the well-pleaded complaint rule. Very broadly, before we break these down in a ton of detail, the well-pleaded complaint rule is this second element, kind of this rule statement. Important to recognize, if I was taking, a law school final exam or I'm on the bar exam, I'm going to start with the well-pleaded complaint rule first. Even though we kind of have it listed as this second element, I'm going to start with the well-pleaded complaint rule because the well-pleaded complaint rule is more of the foundational question. It's more of a gateway issue when we're thinking about federal question jurisdiction. The well-pleaded complaint rule really just asks whether the federal question involved, whether that federal ingredient involved in the case is actually presented on the face of the plaintiff's complaint. If it's not on the face of the plaintiff's complaint, the well-pleaded complaint rule says then there is no federal question jurisdiction. Once we establish that the well-pleaded complaint rule is satisfied, basically, yes, the federal question is presented on the face of the plaintiff's complaint. The second question is the significance rule. Well, is that federal question that's been pled on the face of the plaintiff's complaint significant enough to warrant federal question jurisdiction. Okay, so that's big picture where we're going with these two rules. But let's start with the well-pleaded complaint rule first. Here we say federal question jurisdiction exists only if a sufficiently significant federal question is presented on the face of the plaintiff's properly pleaded complaint. Okay? So the place to start here is going to be Louisville and Nashville Railroad Company v. Mottley. This is one of those cases that everybody's going to read in law school, so it's worth going over in a little bit of detail here. And the takeaway, as we're kind of thinking about Louisville and Nashville Railroad Company v. Mottley, kind of the takeaway here to think about is that no federal question is going to be existent by anticipation. Okay, and so let's break this concept down a little bit. So in Louisville and Nashville Railroad Company v. Mottley, essentially what you have is the Mottleys are injured in a train accident, okay? And the train accident is basically caused by the railroad company's negligence. So out of court, they reach a settlement. The Mottleys and the train company come to a settlement. And the train company, the railroad company is basically like, hey, we messed up, so we're going to give you lifetime passes to ride on our railroad for free. For the rest of your lives, since we did this horrible thing and you've had this injury, you can ride for free. You get a lifetime free pass to ride on our railroads. The Mottleys accept this. And then later on, basically, Congress passes federal law that says the only people that can get free passes to ride on a railroad are the employees of railroad companies, of course, and their family members. Of course, the Mottleys are not family members of the railroad company. So the railroad company calls up the Mottleys and says, hey, we know we gave you those lifetime free passes, but we got to revoke those because this federal law has been passed. So of course the Mottleys say, whoa, we had an agreement. This is a breach of contract. So they sue. So effectively, the Mottleys sue the railroad company for breach of contract, which we know is a state law claim. But the Mottleys say, or basically argue, look, we know this is a state law claim, but we're going to file it in federal court because we're anticipating that the railroad company is going to raise a defense of federal law. They're going to point to this statute that was passed by Congress that basically says nobody can ride for free unless they're an employee or a family member of an employee of a railroad company. So since we know the railroad company is going to rely on this federal law for their defense, we're just going to go ahead and file the action in federal court, even though it's purely a state law breach of contract claim. So it gets to the Supreme Court of the United States in 1908, and the Supreme Court basically says, no, under the well-pleaded complaint rule, a federal court does not have federal question jurisdiction unless the federal question is apparent on the face of the plaintiff's properly pleaded complaint. So this idea of you anticipating that the railroad company is going to raise a defense that involves this federal law, that's insufficient. That does not grant a federal court federal question jurisdiction. So essentially, the takeaway rule that we get is the defendant's response is irrelevant. As the case law develops, we see the Supreme Court really double down on this concept, that there's no federal question by anticipation, and the defendant's response is irrelevant. So the defendant's response, counterclaims, and defenses are totally irrelevant. When we're trying to determine whether a federal court has federal question jurisdiction, what I tell students to do is essentially put the blinders on, right? Find the plaintiff's complaint, like literally the four corners of the paper that complaint is on, and look only at the plaintiff's claim. Anything outside of that is basically irrelevant in determining whether federal question jurisdiction exists. This is the well-pleaded complaint rule. So it doesn't matter. The defendant can be raising defenses under federal law, can be filing counterclaims under federal law, can be responding with anything about federal law, and it's all irrelevant. It doesn't matter. If the plaintiff has not alleged, some sort of federal law ingredient, basically, if there's not a sufficiently significant federal question apparent on the face of the plaintiff's complaint, no federal question jurisdiction exists. This is the well-pleaded complaint rule. It's pretty easy to apply if you know it, because you just put the blinders on and you look at the plaintiff's complaint, okay? And this should make some intuitive sense if we think about it, what the Supreme Court has said on this in terms of reasoning. If you're wondering, well, why do we have this rule? Well, if we allowed defendants to basically counterclaim under federal law, and that would grant a federal court federal question jurisdiction, then it would take the power away from the plaintiff to choose whether to file an action in state law or to file an action in state court or federal court. So assume you have for example, right? Say we have a plaintiff who's filing a state law breach of contract claim in state court. There's no federal ingredient in the action. Well, if that defendant who's being sued wants to move the case to federal court, all he's got to do is countersue. If we don't have the well-pleaded complaint rule, then the defendant could just countersue based on some federal law and then move the action to federal court, even though originally it was just a state law claim filed in state court by the plaintiff. Defendant responds, hey, I'm going to countersue based on this federal law, and then I'm moving it to federal court. Basically, because it would so rapidly expand the class of cases that would be removable to federal court. This is essentially why we have the well-pleaded complaint rule. It's to make sure that a plaintiff who wants to file a state law claim in state court can do so without having the risk of a defendant just countersuing based on federal law and moving it over to federal court. And I know we haven't discussed removal at this point, but we can just accept that's kind of the rationale behind this. We'll discuss removal and how that works in more detail in a future lesson. That's just kind of some of the reasoning behind the well-pleaded complaint rule from the United States Supreme Court. Okay, so that's the well-pleaded complaint rule. Next, we have the significance rule. Here we say the appearance of a federal question in the plaintiff's well-pleaded complaint does not, in and of itself, automatically grant a federal court federal question jurisdiction over the case. The federal question must be sufficiently significant. So our next question here is going to be, once we establish that the plaintiff has, on the face of his complaint, pled a federal question, we put the blinders on, we're looking at the plaintiff's complaint, we're looking in the corners, and we see, yes, the plaintiff, on the face of his complaint, has alleged some sort of federal question. Our next issue is going to be, well, is that federal question presented on the face of this complaint sufficient? Basically, is it sufficiently significant? Is it sufficiently federal? Is it a sufficiently significant federal question? If it's some really tiny, minor federal issue that's just kind of like embedded in a state law claim, we'll see sometimes that's not enough, right, to justify conferring federal question jurisdiction. So when we're thinking about the significance rule, we have two tests. We have the creation test, which is our default rule, and the Grable test, which we apply when a federal question is embedded in a state law claim. So important to recognize here, if we're wondering whether a question presented on the face of the plaintiff's complaint, whether that question is sufficiently significant, we always start with the creation test. The Grable test is kind of a backup we apply when a federal question is embedded in a state law claim. Okay, so let's start with the creation test. This is somewhat intuitive to apply. Okay, a federal court under the creation test has federal question jurisdiction over a case if the plaintiff's cause of action is created by federal law. So like an easy example of this might be the FTCA. We know that, typically speaking, tort claims are state law claims. If, plaintiff sues defendant for negligence, typically we assume that's a state law claim. However, Congress has enacted this legislation called the FTCA, the Federal Tort Claims Act. And basically, the FTCA enables private parties to sue the federal government for certain types of torts. It creates a federal cause of action in torts for private parties to sue the federal government. So if a plaintiff sues the federal government under the FTCA, well, then the federal court has federal question jurisdiction over the case because the plaintiff's cause of action was literally created by federal law. The FTCA, the Federal Tort Claims Act, actually created the cause of action that the plaintiff is now using to sue the government. Okay, that'd be like your most obvious example of the creation test being satisfied. And most of the time, when we see federal question jurisdiction being tested in law school and on the bar exam, the creation test is what's going to be satisfied. It's not as often we see some federal ingredient embedded in a state law claim. Generally, you'll be given some like federal statute. It might just be made up. It might be a real thing, just depending on, how you're being tested. It could be a hypothetical that's invented, for purposes of just testing this on civil procedure, but it'll tell you in the fact pattern, right? It'll say something like the federal Gun Safety Act is passed and it creates a cause of action and the plaintiff is suing based on this. That's how you would know, okay, federal question jurisdiction is satisfied, right, under the creation test. This comes from American Well Works Co. v. Lane and Bowler Co. I'm not going to go into a ton of detail here. If you're following along in the outline, this is section 1C1D. We have a breakdown of this case, but the rule is very straightforward. A federal court has federal question jurisdiction over a case if the plaintiff's cause of action is created by federal law. And like I said, most of the time, this is going to be the case when we're seeing this tested in law school in the bar exam. However, it is possible. We want to be aware of the Grable test. And this is applied when a federal question is embedded in a state law claim. So if we do have a pure state law claim, it's like a breach of contract claim, a pure state law tort claim, but we see some ingredient of federal law mixed into the plaintiff's complaint. It's not coming from the defendant's side, right? If the defendant is raising a defense based on federal law or is countersuing based on federal law, we throw that out. We ignore that, right? That's the well-pleaded complaint rule. We ignore whatever the defendant's doing, okay? And that's commonly tested, and we don't want to mix that up with the Grable test. The Grable test is applied when a federal question is embedded in a state law claim. So it's still on the face of the plaintiff's complaint. It's in the plaintiff's claim. It's not coming from the defense. It's in the plaintiff's complaint, but it's still a state law claim where we see this federal question embedded. So what do? If this is what's happening, we have the Grable test. Under Grable, a federal court has federal question jurisdiction over a state law claim if a federal issue is necessarily raised, actually disputed, substantial, and capable of resolution in federal court without disrupting the federal-state balance approved by Congress. Okay, so the best way to see this is to talk about two seminal cases. We have Merrell Pharmaceuticals Incorporated v. Thompson, and we have Grable and Sons Metal Products v. Darue Engineering and Manufacturing. These are two United States Supreme Court cases. We'll see in Merrell, important to recognize, this is 20 years before we get the Grable test. We'll see Merrell kind of doubles down on the creation test, and we'll see 20 years later kind of how Grable and Sons this new Supreme Court decision distinguishes itself a little bit from Merrell and how we get this 4-element test, okay, that's a little bit separate from the creation test that we call the Grable test. Okay, so let's just break down Merrell first, okay? Remember, this is 20 years before we get the Grable test, but it's important because the Supreme Court in Grable has to distinguish the Grable fact pattern from the Merrell fact pattern. Okay, so in Merrell, the plaintiffs filed a state law tort claim against Merrell. They actually do this in state court, but Merrell wants to remove it from state court to federal court. And Merrell, to do this, argues federal question jurisdiction existed because the state law tort claim relied on an alleged violation of the Federal Food, Drug, and Cosmetic Act, the FDCA. Okay, so actually what we have happening here is the plaintiffs, the Thompsons, unfortunately have a child that is born with birth defects. And during the pregnancy, the mother took these prescription drugs for morning sickness that were manufactured by Merrell Pharmaceuticals. They're alleging under just a state law tort claim that, there was a tortious activity that occurred that basically resulted in these birth defects that the child now has. Okay, so it's a pure state law tort claim, but in that complaint, embedded in their complaint, if you look in the corners, in the well-pleaded complaint, there is this to basically prove their case. They do rely on this violation of the Federal Food, Drug, and Cosmetic Act. Basically, the FDCA kind of lays out standards that pharmaceutical companies have to follow. And the Thompsons, the plaintiffs, are saying, hey, look, Merrell Pharmaceutical did not follow these standards under the FDCA. This is kind of how they're using this as evidence to show how there was this tort committed by Merrell. Okay, so the court found here that the federal issue embedded in the state law tort claim was insufficiently substantial to confer federal question jurisdiction because Congress did not create a cause of action for a violation of the FDCA when it was enacted. So basically here, the Supreme Court really doubles down on the creation test. They're saying, hey, look, when the FDCA was enacted by Congress, they did not create a federal cause of action under the FDCA. These are basically just standards for pharmaceutical companies to follow, but there was no actual cause of action created. So obviously to Congress, this isn't substantially a federal question if there's a violation. Otherwise, they would have created a cause of action for it. Kind of like the FTCA. Remember the Federal Tort Claims Act? When Congress passes this law, they create a cause of action under the federal law for private parties to sue the federal government for certain types of torts. This is different, right? This is the FDCA. And under the FDCA, no federal cause of action is created. So under the creation test, basically the court says this is insufficiently substantial. Okay, this is Merrell Pharmaceuticals. So that state law tort claim needs to stay in state court, even though we've got this federal ingredient embedded where there's this potential violation of some federal standard in terms of manufacturing pharmaceuticals. Because there's no cause of action, it's insufficiently substantial to confer federal question jurisdiction. Okay, 20 years later, we get Grable. Okay, and Grable is where we get this 4-element test. In Grable, the plaintiff, Grable, had his land seized by the IRS to pay off taxes owed. After being notified by certified mail, the land was sold to Darue. Grable then filed a state law quiet title action against Darue. Darue, of course, wants to move this action to federal court. So Darue argued federal question jurisdiction existed because the state law quiet title action depended on the interpretation of federal tax law. basically whether notice to pay property taxes must be delivered in person or by certified mail. Okay, so this is another example where we have the plaintiff filing a state law action, right? This is a state law quiet title action, but we have this federal ingredient embedded in there, right? We have this federal question about the interpretation of a federal tax law, basically the requirements of notice under federal tax law. Does notice have to be delivered in person, or is certified mail sufficient? This is the federal issue in dispute that's embedded in the plaintiff's state law claim. Okay, very important to recognize here, this is not the defendant raising some federal law issue. If the defendant is raising some federal law issue, we just ignore that. That's not even a part of the analysis. Here, we're still in the well-pleaded complaint. If we have our blinders on, we're still in the well-pleaded complaint. It's a state law claim. Embedded in it is this federal question as to the interpretation of federal tax law. Okay? So the court here finds that the federal issue embedded in the state law claim conferred federal question jurisdiction because a federal issue was necessarily raised, actually disputed, substantial, and capable of resolution in federal court without disrupting the federal-state balance approved by Congress. Okay, so we see in Merrell Pharmaceuticals, the court basically doubled down on the creation test. They say, hey, look, when the FDCA, the Food, Drug, Cosmetic Act, was passed by Congress, Congress did not create a federal cause of action. Okay, it was more just like standards that pharmaceutical companies should follow. So they're basically saying, look, if this was something that was like a substantial federal issue, Congress would have created a federal cause of action specifically for it. So because they didn't, basically doubling down on the creation test, it's insufficiently significant of a federal issue. That was Merrell Pharmaceuticals. Here, 20 years later in Grable's basically saying, well, just because a federal cause of action is not created when Congress enacts the law, that's at least evidence, it's relevant of how significant the federal question is, but it's not dispositive. Instead, we're going to rely on these 4 elements: whether the federal issue is necessarily raised, actually disputed, substantial, and capable of resolution in federal court without disrupting the federal-state balance approved by Congress. And here in Grable, Supreme Court says, look, these 4 elements are met. Okay, so the federal issue embedded in the state law claim does confer federal question jurisdiction to the federal court. So we can break these elements down and then kind of distinguish this a little bit from Merrell. Okay, so the first element, the federal issue was necessarily raised. Yes, in this case, the federal issue is the interpretation of federal tax law, basically how notice has to be delivered. Is certified mail sufficient, or is hand delivery, in-person delivery required? And this interpretation is the crux of kind of the dispute. So it is necessarily raised, right? This federal issue is necessary. It's not like some tangential issue that doesn't really have anything to do with the outcome of the suit. This is necessarily raised. Of course, it's actually disputed. Plaintiff is saying, look, I needed to get my interpretation of the federal tax law is that hand delivery is required. Of course, the defendant, Darue, is going the opposite way. They're saying, no, certified mail is sufficient. So we have a dispute over this federal interpretation of the tax law. Is it substantial? Here, the Grable court says, yes, the IRS needs to know how to provide notice to collect delinquent taxes. They need to know whether they have to hand deliver it or whether certified mail is sufficient. So this is substantial. And they say that the federal issue here, the interpretation of this federal tax law, is capable of resolution in federal court without disrupting the federal-state balance approved by Congress. Essentially, what the Supreme Court says here, and this is also kind of how they distinguish Grable from Merrell, is they say, look, State quiet title actions are rarely going to involve federal law issues. State quiet title actions usually are pure state law, disputes. It's rare we get ingredients of federal law in them. So for this reason, this case, this federal issue is capable of resolution in federal court without disrupting the federal-state balance approved by Congress, because it's very rare in state quiet title actions we're going to have contested federal issues. So it's not really going to disrupt any balance between the federal and state governments approved by Congress. Okay, and this is kind of how they distinguished the case from Merrell Dow. The court noted that the absence of a federal cause of action in Merrell Dow was significant because it would have opened the door to a large number of cases involving federal standards without causes of action. In contrast, state quiet title actions rarely involve contested federal law issues. So really, the Grable court is distinguishing Merrell Dow based on this fourth element, right? Capable of resolution in federal court without disrupting the federal-state balance approved by Congress. They're saying, look, under the FDCA and Merrell Dow Pharmaceuticals, if we allowed in that case for people to bring actions in federal court based on state law tort claims for some violation of a standard in the FDCA enacted by Congress, we could just have a floodgate of litigation come into federal court that was not approved by Congress, right? That would be disrupting the federal-state balance approved by Congress. In this case, in Grable, since it's so rare to have these federal issues embedded in state quiet title actions, right, it goes the other way. The Supreme Court finds the federal issue embedded in the state law claim does confer federal question jurisdiction. It really comes down to that fourth element in Grable. Okay, but this is the significance rule. Okay, so if we're thinking about federal question jurisdiction, big picture, remember, we have two components. We have the constitutional component and the statutory component, 28 section 1331. Remember, we really apply 28 section 1331. That's kind of our modern requirements, right? 28 U.S. Code, section 1331. Here we say the cause of action must arise under federal law. So that raises the question, how does a cause of action arise under federal law? Remember, we just need to make sure that the significance rule and the well-pleaded complaint rule are satisfied. Well-pleaded complaint rule, big picture, just says we need that federal issue to be presented on the face of the plaintiff's complaint. Significance rule says, okay, even if it is pled on the face of the plaintiff's complaint, we have to make sure it's sufficiently significant of a federal question. If both of those are satisfied, then the federal court has federal question jurisdiction over the case, which means the federal court has subject matter jurisdiction to hear and decide the case before it. Okay, that's everything we need to talk about for federal question jurisdiction. From here, we'll continue our discussion of subject matter jurisdiction. In our next lesson, we'll get into diversity jurisdiction, which is another way for a federal court to obtain subject matter jurisdiction over a case. But until then, guys, I wish you all the absolute best, and I'll see you at our next lesson.